Welcome to the Law and Technology Column Virtual Conversations. My name is Gour. I am founder and curator of the Law and Technology column at the Leaflet. Before we begin, let me just briefly introduce the Law and Technology column. This is a collaborative initiative between the Leaflet and the Chanakya National Law University. And the idea behind it is simple but important. A lot of power today is no longer just with courts, legislatures, or regulators. It is increasingly embedded in technology, in algorithms, platforms, and data systems that are shaping how decisions are made and how rights are experienced. But legal thinking hasn't really kept pace with that shift. We tend to either celebrate technology or become skeptical of it. But what is often missing is serious legal engagement with it. We litigate after deployment, we regulate after disruption, we theorize after harm. So, the idea of this column is to move that conversation forward a little more deliberately, to create a space where we can think through these questions more carefully from a developing country perspective, and also by learning from what is happening across jurisdictions, and more broadly, to bring together people working in this space, scholars, practitioners, and students, to engage with how technology is actually reshaping law and governance today. Ladies and gentlemen, today we are joined by Mr. Akshay Jaitly. He's a co founder at Trilegal. He's a leading energy and infrastructure lawyer with over 30 years of experience. He also contributes to policy work on energy transition, power sector reform, and rule of law through public writing and the non-profit Trustbridge. Today's conversation will center around his book, Trilegal, The Making of a Modern Indian Law Firm. Welcome, sir, and thank you for joining us today.
Thank you, and thanks for inviting me.
So to start with, in the book again, you describe how Trilegal's approach to technology adoption. It sort of evolved from the very early days of relying on relatively low cost. And you also speak
Free, the
about
word you're looking for is free.
free. Right, right. Okay, let me call it open source tools to sort of building a sophisticated legal technology infrastructure that now places the firm among the leading TMT practices in India. And you mentioned several early and bold decisions, right? Like rolling out BlackBerry devices, and moving all lawyers to laptops. And you speak about adopting cloud-based services, Microsoft servers, as early as I think 2011 or 12, and then later investing in tools for or dashboards for sort of real-time visibility, if I remember correctly. So, sir, could you walk us through the very thinking behind these early technology bets and how being ahead of the curve on technology adoption, it changed the way the firm worked, it sort of collaborated, and at the end served clients?
Well, as I was saying, initially it was because we had to be imaginative because we didn't couldn't afford expensive off-the-shelf software. So we said, okay, we are going to use Mozilla, we're going to use Thunderbird, we're going to use all of these things which were free, open source. Also, Rahul liked the idea of open source in those days. So the philosophically he liked the idea of open
I
source.
think so. He still likes it.
He still likes it, but he understands that we need to function in a slightly different way because of the compatibility and other such things. But anyway, so we once you basically, that's an innovation of a certain kind, that you're using existing tools to fulfill your needs and still provide sort of seamless service to clients, and then that becomes a habit. So when we look at a, even when new technologies are available, we look at it critically to say, okay, just because somebody is selling this as the number one technology in a certain space, and I'm thinking, for instance, of one of the most popular, I won't name it, one of the most popular legal AI technologies that people are buying off the shelf. We said, no, we don't think that works great for us. We're going to invest in someone who is developing this. Um, Both time and effort, and in this case even some money, we're going to invest in them, and we're going to build it so that it's suits our purposes and the workflows that we see in our firms. And so you have lawyers who help to build that, because the lawyers are the people whose
Right.
workflows that those technologies are supposed to support. And it shouldn't be something that is imposed from the top that then lawyers have to adapt their working style to, because our experience has been that whenever something is being imposed which does not fit with workflows and lawyers' working styles, they'll find a way to get around it. So it'll become suboptimal, inefficient, and at worst a complete waste. So that's been sort of our approach, and we continue to have that approach. So even if we look at, cutting edge, sophisticated, expensive technology today, we'll ask the same questions as we did 25 years ago, to say, what is this actually doing for me and the way that I work today and the way that I'm likely to work in 5 years? And am I going to spend a whole lot of money in buying, which then something that becomes a white elephant that is not going to fulfill the purpose for which I bought it? So that's still our, so it was an approach that was born out of frugality, but
Hmm.
it's now become a habit, and a standard operating procedure. And the logic is still the same, though.
Right. Right. So on the same note, you also speak about how this journey it led to a much deeper integration of technology into the firm's long-term strategy, like from creating a digital innovation group to working with Lucio AI to build tailored AI tools. And then I think you also speak about this, allocating over 11% of the firm's overall expenses, uh, which you explicitly mentioned that which is high even by global standards. And I see that underlying this is a powerful idea that you mentioned in the book, that quote unquote, if existing models they don't work for us, we'll create ones that do. And how do you see the role of legal technology and AI evolving within large law firms going forward? And how does it take on the note of culture and strategy to sustain such kind of commitment to technology and innovation?
Well, I think it goes back to the previous question. It's a question of, what is this technology doing for you? How is it making your work quicker? How is it improving the quality of your work? How is it potentially removing some tasks that are tedious, that are replicable, that a machine could do, while at the same time, very importantly, never substituting human judgment in a profession that effectively has always relied on human judgment. So at the moment, we really have to see AI as a tool that enhances and helps the judgment that humans are making, as opposed to something that is going to replace any of that judgment. What it is replacing at the moment is some amount of process, and a deepening amount of process. It's replacing some tasks which are repeatable, which are replicable, which lend themselves to pattern recognition as opposed to original thought. As far as I know, AI is still not doing too much original thought. When that happens, then maybe our conversation will be different. But as far as I look at it, I think I look at AI as a tool that is helping me and my colleagues do our jobs better, and not replacing anyone. One thing that I think law firms are going to have to think about, and any knowledge-based organization actually, is that there are some of the, it's some of the building blocks of the ability to be able to do the deeper analytical thinking is the sort of more repetitive, tedious work that you do in the early part of your career. So if you think of a human being as a small language model, you have to have enough inputs for it to come up with that pattern recognition in the future. So if some of those tasks which now AI is capable of doing, humans don't do, then how do you replace that learning process within a human's brain
Right.
by through training and other tools? That's something that law firms and knowledge organizations are going to have to think hard about, because while clients might be pushing you to say, okay, this thing can easily be done by machine, so I don't want to see an associate's cost on this. That's a fair position in some ways, but at the same time, if you don't want an associate to do that today, then how do you create a good senior associate tomorrow and a good partner day after? So these are some of the questions that we will have to continuously be grappling with into the future.
Right. Right. Um, so we are seeing that in the last few years in India, um, we have seen an extraordinary push to build large scale data center infrastructure, which are driven by cloud computing, by AI, by localization of data. But at the same time, these large scale data centers, they are extremely energy intensive assets, and they sit at the intersection of power regulation, of land use, of environmental approvals, and of course policy. So, particularly to you, from your experience in energy and infrastructure, do you think that India's current framework, regulatory framework, and then power sector framework, are we prepared for the scale of electricity demand that an AI-driven data center economy will require? And so, how do you see the biggest legal and policy gaps which are emerging?
Well, that's a very big question, and that's something I think a lot about, and a lot of my research and other work, policy work, is around those kinds of issues. And it's not just something that is coming from AI, although the AI will be a large source of demand, but it's still a fraction of the overall demand for power that we have. If we want to grow at the rates that we want to grow to be, Viksit Bharat by 2047, there is no question in my mind that we have to uh, radically reform the way that the power sector is structured. And by that, I mean that, at the moment, the way that the electricity markets work in India, there is very little price discovery that comes out of the matching of demand and supply, which is how it works with every other commodity in the market. Now, there are some special features of electricity that make it harder to do so, but the main problem, I think, doesn't come from special, the special physics of electricity. The main problem comes from the fact that we don't think widely enough of electricity as a commodity that needs to be bought and sold. We still sometimes think of it as a public good. We seem to think of it as something that we have to provide our citizens no matter what. And the point is that someone or the other is paying for it. Whoever, it's something that costs money to generate, and it's something that has to be paid for. So, so the thrust of my work is to say, okay, we need to bring in market forces into the power sector to, fundamentally, not just the 10 or 12% of electricity that is bought and sold on our power exchanges, but the vast majority of electricity must be competitively priced through forces of demand and supply. And that's how we will meet the demand in the future, because people will uh, people will sort of build facilities and use technologies all the way from nuclear energy to energy efficiency to fulfill the demand that a growing economy comes up with, provided we can match demand and supply. There are no price signals in the market at the moment, in the Indian electricity market. So, coming back to the specific question of data centers, I think data centers lend themselves very well to specifically two types of energy. One is renewables, and the second is nuclear energy. And renewables, of course, we've been growing significantly for the last 20 years, but nuclear energy has only just been sort of opened to private sector participation with our new Shanti Act, which came late last year. The regulatory architecture and many details are still to come out, including the rules and regulations. But that will hopefully offer a way in which we will be able to use non-fossil fuel energy, non-carbon greenhouse gas emitting energy for things like data centers, but also potentially for various forms of manufacturing and the services sector more generally. But I think that what is really important there is for us to open up the market so that the price of electricity is determined by supply and demand and not by tariff setting by regulators. And the manner in which to do that is, large scale reform of the power sector, which has to be done at the central level and in the states, which is a long story, which perhaps this is not the time to go into. But the broad principle is that we need to let the price of electricity reflect the cost of production. And for those people who find it hard to afford, we should find other means to make them whole, either through direct benefit transfers or through subsidies for agricultural pumps, etc. What should not be subsidized is the price of electricity.
Okay. So on the same line, do you think that the traditional contractual and risk allocation models used in infrastructure projects, are they equipped to deal with AI-driven decision-making systems? And 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 as an extension, what new kinds of legal risks do you see emerging in infrastructure and energy projects because of AI, or say um, specialized technology usage?
Well, I think, there are two separate questions, really. I think that the risk allocation of public to private contracts in India is always been suboptimal, where, the base one of the basic principles of forming a contract, even between two private entities or between any two people, is that any risk should be taken by the party for whom it costs the least to take care of that risk. And there are many risks in these public to private or PPP kind of contracts, whether it's a power purchase agreement or a road concession or any other form of concession, that the public sector or the government tries to pass on to the private sector, even if it is going to cost more for the private sector to cover that risk. So what that means is you either get suboptimal risk coverage, which means that if the contract runs into problems into the future, the private guy will run away, which has happened many times. And okay, the government's got a nice contract to sue over, but if it becomes economically inefficient for someone to perform a contract, they will not perform it. They would rather, litigate and pay damages. So you don't get the infrastructure that you want. So that's either that or that the contracts become the performance of the contract becomes more expensive. So if I have to if there is a risk and if I have to cover that risk, say through insurance, I have to buy insurance, then I will factor the price of insurance into my bid price, whatever that might be. And that means a more expensive asset, a more expensive power, more expensive road, whatever it might be. If on the other hand that risk could be taken by the government, then the private sector will be able to deliver on that contract more cheaply. So that's one of the basic principles of contracting that I feel is not as deeply embedded into our PPP contracting as it should be. So that's one. And I think as far as AI is concerned in these contracts, it's a similar kind of, I would look at it from a similar lens to say, what is the risk that AI is causing to the execution of that contract or to the performance of the party's obligations? And who's best placed to take that risk? I see AI in these contracts not so much as a source of risk, but I see it as a source, as a tool for contractual performance. I think that it will be so not just AI, but things like blockchain. I think is going to be quite useful to be able to evaluate and validate the performance of obligations under a contract. So I think that I don't necessarily see that as an additional bucket of risk. But if there are, if there are parties within a contract such as this that are relying on AI generated data in order to take certain decisions under the contract, then that somebody will have to decide who takes the risk of that data being incorrect. And somebody will have to decide to take it. And going back to what I started off by saying, whichever party finds it cheaper to take that risk should take that risk, and the other party will, compensate for that by taking some other risk in the contract.
Right, right. Um, so towards I see that towards the later part of the book, you reflect on the future of profession and integration of AI into legal practice. And you describe that how functions they traditionally sort of centered on precedent storage and document retrieval are they're likely to sort of evolve into AI powered systems that analyze patterns across, say, transactions. They offer instant sort of guidance on questions, on complex or say novel questions, and perhaps even they might anticipate the required regulatory changes. And so on the similar line, you also suggest that law firms they may develop sort of proprietary tools. Um, those might be capable of predicting case outcomes or say identifying the transaction structures, and at the same time providing real-time compliance. One line that really stood out to me in particular was that your observation that humans in the law firms they will continue to matter, but will lose relative importance if they do not learn to work with AI. Um, so how do you see this transformation unfolding over the next decade, and what should young lawyers be doing today to remain relevant in a very new AI enabled legal profession?
Well, if I knew how this was going to unfold in the next 10 years, I would make many hundreds of millions of dollars. So I'm not that guy. But I think that I'll take the second part of your question, which I think is it's actually a more analog question and not so much of a digital question. What it will take for lawyers to remain relevant is not going to change. It is going to be keeping up with trends and remaining curious. Now, so AI is another trend. There will be changes in law. There will be changes in the importance of sectors. There will be changes in global priorities, in geopolitics, in all kinds of different things. Lawyers, to stay relevant, will have to keep in touch with all of these and not just rely on AI, which is a bit like spoon feeding if you don't use your own brain to take care of problems. So I think it is remaining interested in the context of within which you are doing your work. I often say this to younger lawyers that if you're going through the list of due diligence checklist, which is a really boring task potentially, and it's 12 o'clock at night on a Friday and you want to go out with your friends, and what is it that keeps you motivated? Ask yourself, why is this transaction happening? What is the sector that this transaction is happening in? Why are these two parties doing this deal with each other at this point in time? How does it fulfill the strategic objectives of both these parties? Is the deal happening because of tariffs in the US or because of war in the Middle East? Is that pushing the deal in some way? And obviously, that's not the moment in which you'll be asking all of these questions because you'll be tired and cursing your boss. But the point is that any piece of work, if you look deeply at the context within which that piece of work is happening. That work will become significantly more interesting. So that's my sort of one of my top pieces of advice to young people going into the profession is stay curious, remain interested in the context. Don't just think narrowly, say, I want to be a great expert in doing this type of securities contract. Okay, that's great, do that. But if you don't have a broader interest and a broader perspective as well, you're going to be limited in what you can achieve as a lawyer. So I would sort of answer the question like that, and not. I would also generally advise people to be little less anxious. I find that young folks are really, really anxious. Lawyers are really anxious about what's going to happen, and I know it's a tough place out there, but uh, being anxious is not going to make life easier.
Right, right. In the book, you describe how the founding of Trilegal was shaped by a shared dissatisfaction with the kind of law firms that existed at that time. And the founders were very clear about what they did not want to build. And from that clarity emerged a set of core values, as you have highlighted in the book, on equality and respect, on meritocracy, on ambition, on client centricity, and then what you call firm mindedness and fraternity. So these values are easy to articulate, but much harder to sustain as organizations grow, when they become more complex, and when they operate under increasing commercial pressure. From a very broader institutional perspective, what does it actually take to translate such founding values into such a long-term organizational practice? And were there moments in the firm's journey where preserving these values required difficult or uncomfortable choices?
Yeah, it's funny. It's not as if the firm one day reaches a size where suddenly it becomes difficult to stick to the values that you started with. I think it's what's really important is that there were six of us who shared the same values in the first place, and that we didn't change our values personally across the time that we've been running the firm. And for the last several years, it's not just been the founders in leadership, it's been various other people in leadership as well. And I think, what you said was quite significant, which is that these values are easy to understand. And I think you have to trust the fact that other people will also find these values easy to understand. Many people actually do want to follow these values, but very often I think human beings are quite funny. They have these values for themselves, but they believe that other people will not have these values or not want to follow them, so they treat people with an attitude of mistrust, because they say, okay, I'm this great guy, but I don't think you are. So what happens then is that it becomes harder then for people to cooperate and collaborate. So I think one of the important things is that we trusted that the people who were willing to become part of the firm and its journey would basically subscribe to the same values. And importantly, we have demonstrated through the 26 years of the firm's existence that it's not just something that's a nice to have, but we very much believe that the values and the structure that we created based on those values is the reason for the success that we've had. It's not that we have our values in one space, but we run the firm like a commercial machine, extracting every last minute of value from everyone. It's the two working together. So I think that it's like when you meet someone after a long time, when you're a kid, they'll say, oh, you've grown very tall. But to your parents, you've not necessarily grown very tall, because you're seeing that on a day, they're seeing you on a day-to-day basis. So for us also, we might have seen the firm become very large, but for us, the firm is sort of, it's just a larger version of what we started off with in the beginning. It isn't this quote unquote big law that people seem to refer to it as from the outside. So we've managed to grow in a way that is kept in line with the values. And importantly, what we found is that a lot of that growth happened organically. It happened from people, progressing within the firm. And once we reached a certain size, we realized that there was a demand in the market for a firm like ours, which had the values that we have, and of course, importantly, the structure that those values have created. So it's clear that there are people who share the same values, who want to experience the culture that is formed by those values, and therefore, I don't think that following those values has been as difficult a task as some people might imagine. However, and that's the second part of your question, have there been moments when it's been hard to follow them? Yes. I think that there have been moments which test any organization, and they test the principles that that organization follows. And we've had 4 or 5 instances within the large instances within the in the firm's journey where those values have been tested, and happily we progress by going back to the values as opposed to by rejecting them, and also by sort of appreciating as we matured ourselves as human beings and professionals that values can find expressions in a changing structure. You don't need to have exactly the same structure to be following a set of values. You can have, the structure can evolve while keeping the values in place.
Right. So you in the book you reflect on the early strategic decision to prioritize international relationships and also cross-border work. Like particularly, Trilegal was a first generational firm without legacy domestic corporate relationships. And so you note that international firms and their clients, they were often less concerned with pedigree, and they were more focused on how a firm thinks, how they approaches problems, and how they deliver work. So could you take us back to that moment of strategy? Like what did it mean in practical terms to sort of build credibility and trust in international markets as a very new Indian law firm, and how did that decision it shaped the firm's long term positioning in the legal services market? So you are mute.
Yeah, and so it was partly a strategy, but it was a strategy that was born out of necessity. We just didn't have the credibility to go before, the big names of the Indian corporate world and say, "Give us your work," because they already had established relationships with sort of founders, or at least families or individuals that had set up and were running large firms. And they had no reason to switch to somebody like us for no specific reason. It did start happening, but it happened either because there was an individual who knew us in one of those organizations, or because we'd appeared across from them on a transaction. They liked our work and they said, "Okay, for a different kind of deal, let me try out, a new firm which has a slightly different type of approach." So, it was just a lot easier. And as you said, if we got the opportunity to pitch to an international firm or to an international client, we would really think hard about what is it that they're trying to do, what is the business they're trying to set up, or what is the transaction they're trying to execute, and how would we approach that transaction, and try to sort of respond to what the needs of that client were. And the manner in which firms overseas were used to buying legal services was to sort of look at, okay, if there is someone in front of me who's telling me how they'll solve their problem, I will give that a fair hearing and listen to them. And they didn't. Also, the market was quite nascent at the time, at least in the form that it is now after 1991 and liberalization, where those kinds of transactions and those kinds of structures and even sectors hadn't sort of opened up. So no one could really claim to have decades worth of experience on some of those newer areas of the economy. So if we could come up with some good ideas about how to execute a deal, these a lot of international folks were willing to listen. To be fair, we also had a bunch of startup type of clients, Indian clients at the time, who either couldn't afford the other firms or we spoke the same language as them because we were similar to them in age. And many of those relationships continue to exist even till today. So it was a combination of, what a certain part of the market, the international part of the market, was sort of responding to, and the necessity of us having to find clients outside of the large traditional Indian old economy firms, companies, and over time, of course, many of those have become long and established clients of ours as we have also become older.
Yeah. Um, so one of the themes that really stands out in the book is that how early Trilegal recognized the shift towards technology-driven business models, and it well positioned itself accordingly. And you describe working with I remember you writing in the book academic entrepreneurs, and you speak about hardware innovators, policy pioneers, at a time when many of these sectors they were still emerging in India. And you also talk about creating new legal templates, including, I think I remember, one of the earliest sort of academic entrepreneurship partnership structure. I think it was IISC, you mentioned, and later advising on major telecom and technology linked developments, like from geo spatial data regulation, to telecom rollouts, and infrastructure sharing. And and at the same time, you you observe that lawyers in such environments, they often have to think like engineers and policymakers, designing structures, and risk allocation frameworks that sort of match the pace of technological change. So my question is, at this backdrop, that how did the firm develop this ability to engage with emerging technology sectors so early, and then what does it takes for a law firm to move simply advising on transactions to actually shaping legal architecture, of new industries, or let's say sectors.
Well, I'll answer your question in two parts. One relates to technology, and the other relates to an approach towards law firm building. As far as technology is concerned, I think that uh, all of our careers, the 30 odd years that we've been practicing, the founders, it's sort of the period of the internet as we know it. So we were starting our careers with the as the internet was starting as well. So it was perhaps easier for us to adopt and embrace a technology that was our sort of contemporary. Maybe for people who were even 5 years into the profession before us, and certainly those who might have been a decade or more into the profession, it was more like you are adding an element to what you're doing rather than that technological element becomes a fundamental way of your functioning. So, so it's like, is it an add-on or is it part of your architecture itself? And I think because of timing, potentially, we were lucky that, email had just about come into formal existence and regular use in organizations at the time that we started. Hotmail, was sort of operational. The first big Hotmail deal when Sabir Bhatia sold the company for 500 million. Everybody thought this is crazy. That those transactions were just beginning to happen. So our careers have sort of coincided with that. We also had the good fortune that one of us, Rahul Mathan, was just deeply interested in technology as a hobby and as a sort of personal interest. And so he wrote this book called The Law Relating to Computers and the Internet in '99, even before the the firm started or there was much of the internet. So it was sort of personal interest and timing on the one hand, on the side of technology. And then once you do that, it becomes a habit. You just get used to using technology as a fundamental, or technology becomes a fundamental part of how you operate, as opposed to it being something that you add on. So that's one side of it. And the firm building side of it is that, we've always had this instinct of looking at ways in which we can build new practices, because we sort of had to do it from scratch as it was. And as I said earlier, a lot of these sectors were just opening up at the time. So what you described in terms of technology, we also were doing similar things in banking. We were doing similar things in renewable energy, where we were doing stuff that was just beginning to happen, and that we had the curiosity, the instinct, and the business sense perhaps to dig deep into how those transactions could take place within India, taking some amount of guidance from what was happening in other parts of the world, and sort of take it from there. So those were both those things became part of the DNA of the firm, looking for new opportunities as and when they arise, doing the legwork slightly ahead of time to learn and to be able to do those transactions once they become more common, as well as on the other side of adopting the technology and using it as part of our operating system.
Yeah. Um, so another fascinating, I think, aspect in the book is how you describe of how Trilegal it made what you call sort of calculated bets on emerging practice areas, often at a time when the market itself was still forming and the demand was not fully yet visible. And at the same time, you speak about investing in knowledge, building capacity early, and sort of committing resources even before the wider legal market um, had fully recognized the opportunity. How does a law firm develop the conviction to invest in emerging areas so early, and what does it take to move forward looking bets while the world is still catching up?
Well, the investment was largely an investment of time and effort. It wasn't an investment so much of money. So we didn't necessarily have the money to invest, but we had the inclination and the time. And where did the inclination come from? And here I'll go back to talking about the structure. I think for the founders, okay, it was a bit different because we set it up. So we had this entrepreneurial spirit, and that same entrepreneurial spirit that you have towards setting up the firm, you apply the same thing towards setting up new practices. So you see, and it's basically a question of, is there an opportunity? Can I take advantage of it? If I can, what do I need to do to take advantage of it? And I think on the structure side, other than the founders, the fact that we are an all equity kind of firm, or the fact that we are a lockstep firm where everything goes into a pot and is shared, people recognize that supporting individual initiative within some sensible parameters makes a lot of sense, for the future, for the building of practices. So I'll give you an example of some things we did not invest in because we did not think that they would lead to necessarily, large lucrative practices. Take sports law. Now, many people are interested in sports law, and today's sports law has become quite big. If you think of IPL, you think of all of that. There's a lot that's going on. But if we had tried to do something like that in the early 2000s, it would have been a waste of effort at the time because there were no transactions that we could have done. However, the idea that that there would be more and more transactions relating to technological advancements, that there would be more work happening in relation to new forms of energy, that India would continue to build more and more infrastructure, that, all of this kind of thing was sort of semi obvious. And the incentive that beyond the founders of the fact that all of their effort, if it paid off, would be rewarded, allowed people to do that. If you're someone who's just sort of taking a salary, and it's isn't aren't going to be rewarded for extra effort and taking initiative which is above and beyond what your day-to-day job is, then you're not going to be inclined to do it. So I think it's having created that environment because we ourselves were entrepreneurs. And so other people with an entrepreneurial spirit then could take advantage of that as well.
Right. Um, so you speak about moments when partners they consider leaving Trilegal, like for instance to build a technology law practice, and in another instance to build an employment law practice, and how the firm ultimately found ways to support those sort of ambitions from within. Because looking back, these are success stories. But what I want to go back to is the human moment before the solution was found. The the conversation in the room when someone you have built something with for years sit across from you and say, "I think I need something else." What do those sort of moments they actually feel like, and how do you hold on to someone without holding them back, and how do you know whether to let them go or ask them to stay?
Well, for two different examples, the employment law example, Ajay Raghavan didn't want to go anywhere. He just said that I want to pitch for partnership based on setting up an employment law practice. So Ajay joined us in the first or second year of the firm's existence. He'd been there for his whole career. We knew him well. We liked him very much. He was very enthusiastic, earnest, sincere, hardworking, clever. So if someone like that who has dedicated their career to basically a startup and has taken a risk with you, if they come and say, I want to take a further risk to build this practice, and here is the background work that I've done, and he had done a lot, and please back me in doing this. It's not such a difficult decision, and the human element is that and you like and value the person in front of you. So that was one. For the conversation with Nikhil, Rahul, I wasn't there when it happened. Rahul had that conversation, but from what I understand, it's Nikhil wanted to go and build a technology, not a technology law firm, but a sort of a legal tech service provider, completely different type of organization, not a law firm at all, but a company offering services to law firms. And that's when, again, Nikhil has spent his whole career with us pretty much as well. And Rahul would have, I think, again, had a similar kind of thought process in his mind. Here's a guy who is a trilegal guy through and through, thinking of something interesting. The reason he's thinking of this is because he's got an imaginative, curious mind. He's done a lot of work. He's understood technology in a way that lawyers tend not to, because they don't really need to in terms of their practice. How do we make this work within the organization? So, in every one of these decisions, the human element is critical, because if the person in front of you is not someone you're particularly fond of or value, then you're going to say, "ठीक है, you can go."
Right.
Because you don't have to make the mental effort of finding a way to accommodate what they're proposing. But if you like someone and the idea sounds good, then why would you not say yes?
Right. So that would be it for today. Thank you, Akshay sir, for joining us, and
Not at all.
also to our listeners. Thank you for being with us, and we'll continue to bring conversations that engage seriously with evolving relationship between law and technology through our very law and technology column at the Leaflet. And do stay connected with us and follow the column for upcoming discussions and writings in this space. Thank you for listening.